During his time as the NRI Director and the Chairman of the National Lands Development Task Force, Dr. Thomas Webster raised issues with the government on the process they were taking to rectify the abuse of SABLs in the country.
The Cabinet, when they established the ministerial committee of the key ministers, Forestry Minister, Lands Minister, Agriculture Minister, to form the committee and implement the Commission of Inquiry, I wrote a letter of protest to the Prime Minister saying, look, these are the ministers and their departments who were already involved in the process of issuing the special agriculture, because they were the ones who were involved in the process of issuing special agriculture businesses, and they should not be involved in trying to fix it.
On August 20th, a court order by the Wewak National Court quashed the draft report and COI recommendation on the SABLs. This court order was a result of a case mounted against several entities of the state by the East Sepik Provincial Government and Limawa Holdings Limited. Dr. Webster says this decision comes as no surprise.
What it does is it's now thrown out the whole work by the Commission of Inquiry. Cost more than 15 million kina, 2 years of work, and other subsequent work since 2013 after the report is done. So we go back to square one again.
Northern Governor Gary Jufa, who has been vocal on the issue, says the government needs to take this decision to the higher court.
The government should appeal it immediately. The Commission of Inquiry was sanctioned, initiated, funded by the government, so they have a responsibility to taking it to the next level.
The Commission of Inquiry into the SABLs was the government's response towards the uproar against the widespread abuse of these leases. In theory, a special agriculture business lease is a way for a customary landowner to register their land if they want to get involved in an agricultural business. Between 2003 and 2010, it was found that 5.2 million hectares of land were registered under SABL, mostly to foreign-owned companies and as a cover for illegal logging. Since the uproar against this abuse, different approaches have emerged in ensuring the customary landowners regain and maintain customary control over their land. On the one hand, political leaders like Gary Jufa have set up independent investigations in their provinces and have been successful in holding to account those found to be in the wrong.
Basically dealt on the matter. The landowners took the case that what had happened was illegal. So we were not basing our efforts, our legal efforts, on the SABL inquiry. So in my opinion, it has absolutely no impact. We've already stopped that. This was in the Collingwood Bay area. The landowners and the provincial government worked together to basically stop that effort over there.
On the other hand, institutions like the Lands Development Task Force have backed the transparent registering of customary land and have helped in putting in place a new land law that helps customary landowners register their land while still maintaining control of their land. So far, with NRI in the lead, they have assisted 2 customary landowning groups to register their land.
2013 and 14, we've implemented and piloted a few programs using those legislations. So in a way, we've come far and we've got an alternative mechanism that customary landowners can use to register and lease their land. So what the state needs to do is go out in full force to implement that. And
this happens while the Lands Department continues to struggle under constant scandals of mismanagement, with the recent arrest of suspended Secretary Romilly Kilapat for misappropriation of funds. Sarah Aupong, National EMTV News.